first Jonathan on procedural rules implementing state immunity from the execution, and then of course there is Mathilde avec l'immunité d'exécution de l'État. Donc, Jonathan, you have the floor.
Thank you very much. So, your client comes to you and asks you, tells you that he or she is the beneficiary of an award or judgment against a foreign state, and say the state won't pay it voluntarily. How do I get my money back? Or you teach a class on public international law, much more likely it seems from this crowd, and you wonder, is state immunity from execution applied solely through international law rules, similar to the one found in the 2004 UN Convention on State Immunity? Well, in either cases, you should absolutely read my thesis. My name is Jonathan Brosseau. I'm a PhD candidate at Paris 1 Panthéon-Sorbonne and McGill University. I'm doing my thesis under the supervision of Professor Matthias Odi and Andrea Björklund. And my thesis concerns the rules implementing state immunity from execution in practice. So today my presentation has three parts. First, I'll explain the scope of my thesis. Second, I'll address the problems that the thesis seeks to solve. And third, I'll set out some of the challenges that I face in drafting the thesis, and I have some questions for you, so be ready and you must listen. But before, just a word of caution, I do have a few jokes about state immunity, so please don't judge me. First, the scope of my thesis. What types of rules are implementing state immunity? Here, I'm not examining directly substantive rules, such as on the distinction between commercial assets, which are seizable, and sovereign assets, which are not seizable under customary international law. Rather, I focus on the rules of civil procedure that implement the distinction. So I'll give you a few examples. The rules on the service of process, provisional or interim measures, prior authorization procedures, when you need to go to see a judge or a government official to ask to have measures of constraints against state assets, the effect of sanction on measures of constraint, access to evidence, burden and standard of proof, and measures against state-owned entities, sovereign wealth funds, and central banks. So I felt a little bit rebellious, and since we couldn't have a PowerPoint, I brought a visual aid with me to illustrate one of those rules, because that might seem a little bit abstract, rules of civil procedure for public international lawyers. And I want to speak about the rules on the service of process. So what are those rules? So basically, when you want to serve a defendant in a civil procedure, all states have specific rules to do that, but they also have typically special protections to serve defendants abroad. And this is the basic goal is that in terms of fair trial components and aspects, the defendant abroad should know of the proceeding against it. And when it comes to foreign states and the procedures against foreign states, there's even more protections, and these are the ones I'm discussing here. And typically what you get is you need to serve through diplomatic channels. What does that mean? It means that you must serve through your Ministry of Foreign Affairs in the country where you're trying to serve, and the Ministry of Foreign Affairs will forward the document to the embassy in the foreign country, then through the Ministry of Foreign Affairs and through the Ministry of Justice. So this takes a lot of time, and basically, I don't know if some of you are Amazon Prime subscribers. I'm not, because I'm very poor, but this is basically what you get when you order a 24-hour delivery on Amazon. It says, for instance, that the car has left the garage. So here, maybe we're talking about use cogents or not, and don't want to make too much of a digression, but do you want to know what you get when you serve through diplomatic channels? It's very easy, very clear. You get nothing, basically. It can take 3 months, it can take 6 months, it can take 2-3 years, and you get nothing. No information of what's going on. And the question here is whether that violates the creditor's right to a fair trial under constitutional law or human rights law. And for instance, the UK Supreme Court came to a decision last summer in a case where it found that service through diplomatic channels was a mandatory and exclusive procedure under English law. So basically, courts had no power to dispense with, even though in that case, there was a civil war in Libya, which meant that the embassy, the British embassy in Libya was closed and service through diplomatic channel was impossible. So I come to the second part of my presentation and I address the problems that I'm seeking to solve in my thesis. There are broadly three questions that I look for each of these rules. So the first question, very easy, are rules coming to the correct interpretation of the rules, are courts coming to the correct interpretations of the rules of civil procedure under their respective national law? That's quite straightforward. The second is whether there are rules of civil procedure on or related to state immunity from execution under customary international law. And that matters for two reasons. So first, say the protection offered to foreign states establish a minimum level of protection that is here, and then the rules under national law provides a lower protection. Well, in that case, quite clearly, there's a violation of customary international law. That also matters for another reason, because if states provide through their own rules of civil procedure a protection that is much higher than the one provided under customary international law, then it might be breaching the creditor's right to a fair trial, again, as I mentioned, under constitutional law or human rights law, such as the European Convention on Human Rights. And then the third point I'm looking into is what are the rules of civil procedure that best serve the goal and the purpose of state immunity. So in terms of methodology, you won't be too surprised to know that I use the methodology of comparative law. And I have a few hypotheses. It's a bit difficult to apply them specifically to each of the rules in such a short amount of time, but I'll share a few. So the first is that some of the rules violate the creditor's right to a fair trial, among others because they are meant not to protect the foreign state, but because they are meant to protect the forum state, so the state where the proceedings are brought. And here I gave the example of service. A second point is that, contrary to popular belief, there are rules of customary international law on civil procedure implementing state immunity, even if these are indeed very rare. And here I think of rules on default judgment. And for creditors, there are workarounds to the hurdle posed by the rules of civil procedure through clever lawyering, but these sometimes lead to a bending of the rules. And there's quite a lot of jurisprudence in the UK where lawyers pay a lot of money, have made very interesting interpretation of the rules, which have stand for a long time, including on service, but the Supreme Court has put an end to all of that. And my last point is that states have a common interest in the satisfaction of foreign states' debt, and that in that sense they should harmonize their rules. And there's a more likelihood that they manage to agree and harmonize rules on procedure rather than substantive law. So I come to my third part, the challenges that I face in my thesis, and my question for you, since we are in presence of the most brilliant international students in the world. And my questions are whether there are more rules of civil procedure that I should study, or whether there are other interesting issues that I should try to resolve rather than just the three that I've mentioned. And then another point, which is quite interesting, is that on customary international law, a big challenge that I face is to seek to identify the rules of civil procedure, because it's very difficult to find specific state practice. And here, let me give you two examples. So on substantive principle, so for example, the prohibition on the use of force, it's a little bit easier to identify principles, but when you're trying to look at procedural rules, then you really get into the nitty-gritty of things, and is state practice specific enough? So again, to give an example, use the one of service. If a state allows service by mail, but only if service by treaty has failed after 30 days, and another state says, I'll allow service by mail as well, but only if the treaty allows it. And so it just shows that the delays are different between states, but the question is there still a principle that is customary in nature? So I'm happy to take your question, discuss now or later by email, and specifically if you feel like there's certain development in your jurisdiction that is interesting, or whether you have faced interesting comparative law methodology issues, or perhaps that's beneath public international lawyers that don't want to deal with comparative law. In any case, I thank you very much for your attention, and also to Professor Bartolini for organizing these wonderful doctoral meetings.
Thank you, Jonathan. And now, let's see if Matilde can also sell her book. So, Matilde, please, you have the floor.